Okay, thanks so much, Angela. Good morning, everyone. I am happy to present this material with you, and I say with you because we will have some time typically at the end to address sort of in a shotgun approach your questions, because there's always questions. And as much as I try to pack in this hour, there's things that just escape, and so feel free to reach out with your questions. My contact information is here. In the event you do have a question, you should feel free to shoot me an email, and I'm happy to take it offline as well. I present this on PowerPoint in an unconventional use their slide show so that I can control what I'm highlighting and showing you. And I find that works a little easier, even though there's some clunky parts to it. All right, let's jump into it. This slide depicts really the essence of estate planning. And by that, I mean the first part of the consideration is whether someone loses competence, loses the ability to make decisions for themselves. And the two legal issues with that is who is able to make decisions for you in the medical decision-making process, communicating with doctors, getting access to your medical information should you lose mental capacity. And then the second piece of that is who can access and work with your financial matters, starting with your bank account, maybe your retirement money, dealing with your home, and so forth. So that's what I would say is this left side of the screen, losing capacity. We hope nobody ever loses capacity. You live out a nice, full, comfortable life, and one day you pass away. We know that's going to happen. So that's the right side of the screen. We know you need to plan some things for the right side, and we just call it what if I die, not what if, but when. So the people who like to do planning are the people who are addressing things like what does the family do after you pass away? Who is going to receive what? And as this slide depicts, when are they going to get their money? Most of the time, people just disperse the money to the family, but there are instances, like we'll talk about today, where that's not such a great idea. So those are my legal issues. Let's look at what my clients tell me their goals are for estate planning. And nobody likes to pay taxes or see their money minimized with taxes. So that's our first goal, is how do we reduce death taxes? We're not talking about income tax. That's a whole different presentation, perhaps. But for death taxes, there is good news that most of us will not have. It's also known as an estate tax. Most of us will not have an estate tax because when you look at the three estate taxes in Maryland that could occur, the first one being the federal estate tax. Well, the feds are not interested in taxing you or getting any of your money unless you have an estate worth more than $14 million. And if you're married, that's 14 million plus 14 million, potentially a $28 million exemption before there's a tax. The tax is horrible, it's 40%, but it's only 40% of the dollars going over 14 million. So that leaves pretty much all of us out of that category. Then you have the Maryland estate tax. The Maryland estate tax is not quite as generous, but still pretty darn generous. If you're, and I should change this, this figure, if your estate is no more than, no more than $5 million, then you don't have an estate tax. The reason I had 10 million up there is if you're married, then it goes up to 10 million potentially. So in other words, less than 5 million, nothing to worry about. More than 5 million and you're married, you can work with an attorney to make sure you have a $10 million exemption. The tax above that exemption, 16%. Nothing like the Fed's 40, but still a fairly painful tax for the heirs to have to endure. And then the final Maryland death tax is called the inheritance tax, and it has a different name and a different application. The reason for the inheritance tax is who are you leaving your money to? And so more distant relatives are taxable. Now, to me, a niece and nephew is not all that distant, but that's where the legislature drew the line. And of course, cousins would be more distant. And then non-family members are certainly going to suffer a 10% haircut on their inheritance to pay the Maryland inheritance tax. The good news is most of us leave money to these exempt beneficiaries. And so there will not be any inheritance tax. So with taxes out of the way, we go to our second goal, and this circles back to the first slide about who can control your assets and healthcare decisions if you lose mental capacity. And who do we have here? I mean, we have two documents. So the first document pertains to your assets. And this document is critically important because assets can be frozen if you lose mental capacity. And it doesn't matter for some of those assets, even if you have a spouse, they're frozen. So no one is allowed to sign your name to the deed to your property as if it were going to be sold or gifted or transferred in any way. It cannot be signed by your spouse. And they know that because there's a notary making sure that you are signing your own deed. But if you're not competent, you're stuck. Another way you could be stuck if you lose competence is your retirement money. There is no co-owner of your retirement money. That's why they call it an individual retirement account. And so your spouse could be stuck not being able to access needed funds down the road. So the solution is a document, and it is given the name power of attorney or some variation of that. It's important that the document be very comprehensive, covering every conceivable transaction that they might need to use your power of attorney for, because if it's not mentioned in the power of attorney as having authority, they don't have that authority to, let's say, open your safe deposit box if it doesn't talk about a safe deposit box in your document power of attorney. What happens if somebody loses capacity and doesn't have a power of attorney? And it could even be a spouse in this jackpot. They will likely have to file with the circuit court to become guardian over their spouse. Now, in this category, we're talking about assets. So it's guardian of the property. So guardianship is in two flavors, guardian of the property and guardian of the person. Going for guardianship is very undesirable. It can rack up some legal fees. It's generally permanent, so you can't just get rid of it when you're done with it. And it can be contentious within the family when son wants to be guardian and daughter says son's no good, I should be the guardian, I'm going to try to block you in court. So all that's avoidable if you just have a power of attorney and you set up the scheme of who's in charge in any order you want. You can have two serving at the same time. We call them agents. So pick an agent and make them in charge. On the healthcare side, if you lose capacity, the question is who can make your decisions as your health care agent. Now, a lot of times you don't see this being a problem because doctors, hospitals, they kind of want to cooperate with the family. And they look the other way when it comes to having a written document. But where this can blow up quickly is under what's called the Privacy Act. also known as HIPAA. And under the Privacy Act, federal law prohibits a medical provider from giving information about the medical condition or documents of the patient unless there is some waiver of that privacy. So by doing an appointment of healthcare agent, you will waive HIPAA and let your family have access to your medical information. And if they disagree at bedside as to, son wants this done and daughter wants that done, they might be in litigation over who is in charge. And instead, the court's going to say, we need to appoint a guardian over the person through the circuit court. Same as before with assets, expensive, permanent, and contentious. So that is the way around those two issues. The third goal, people want to know that when they pass away, their spouse or their children are going to have everything go smoothly with the least amount of cost possible. So while there's no guarantees that you can assure people this will happen, there are measures to be taken to minimize cost and hassle. So it really is driven by what your assets are to be able to have those assets transfer smoothly and without time delay. So most people have a home, a vehicle, or retirement accounts, bank accounts, and so forth. So we say to you, do this exercise. List each of your assets on a piece of paper and then run a drill and say, okay, I just passed away. What happens to my car? What happens to the belongings in my house? How do these assets pass and to whom and how quickly? So I'm going to give you a little schematic that really helps people see visually what we're talking about. In a way, there's only three possibilities for how your assets will pass. You might own assets jointly, typically with a spouse. And so when one joint owner dies, the other joint owner becomes the sole owner instantly, automatically. The deed to your property. If one spouse dies, the other spouse owns the property. You don't even have to have a new deed written up and filed showing the sole owner. A death certificate is enough to establish that the survivor owns the property. The second way to pass assets is by using beneficiary designations. And so there's some very common investments or assets that deploy the beneficiary designation, such as life insurance. Of course, you buy life insurance, one of the first things you're asked to do is designate a beneficiary. Retirement money, I just wrote IRA up here, but retirement money also has you complete a beneficiary form. An investment called an annuity will do the same thing. And then we'll talk a little more later about these last three, pay on death, transfer on death, and life estate deed. These are yet three more ways to name a beneficiary of bank accounts, investment accounts, and the deeds to your properties. So these two are sort of quick and easy. And then we have the default. If you're not under box 1 or box 2 with an asset, that asset falls under box 3. And what box 3 is saying is immediately after death, those assets are owned by this entity called your estate, sort of a fictitious government-created entity to hold title to individual assets that don't have anywhere to go yet after you die. What are the rules for how this estate is going to maybe get to the family someday? Well, those rules are called the probate rules. And the government imposes all these requirements before the assets can be distributed. So under the government's probate rules, the first thing to look for is whether a will was executed by the deceased person. And that will sort of becomes the operative vehicle for determining who's going to be in charge of administering the estate. And then the probate rules are just simply about, hey, you got to report the assets to the Register of Wills office. You have to jump through various hoops. And within about 7 to 10 months, the probate process can wind down so that the family members can inherit as you prescribed in your will. If you don't have a will, the government wrote a will for you, and that's called the laws of intestacy. And generally, the laws of intestacy try to steer your assets, your estate, to your family members, but it just may not be the way you wanted it. For example, if you have a spouse and children, they're going to have to divide the money between the spouse and the children. You may want your spouse to have all the probate assets. These are called the probate assets. Now, your spouse might get most of the assets because they're a joint owner or a beneficiary. So remember, this concept here is those assets that don't have a joint owner or a beneficiary. So what we have just covered this so far are the three critical estate planning documents: a will, a financial power of attorney, and a medical directive. So what is the estate planning process? Besides considering having these documents, is communicate with your family what you are thinking or what you are doing so that you cut down on the hurt feelings after you're gone and possibly the fights after you're gone as to who you chose to be in charge, what you did with certain assets. Maybe you gave the piano to Charlie because he likes playing piano, or you gave earrings to the daughter-in-law because you don't have any daughters. So things that you might do, it's great if you communicate them with your family as you're doing your estate planning process. So let's look at some of these documents. The first, the will. Remember, the will only addresses probate assets. It does not help you avoid probate. And that's a misconception with people, as this slide again depicts, that the individually owned assets pass through your estate. That's what follows the will and eventually gets to these beneficiaries. The ones that avoid probate are box 1 and box 2. Probate. I keep saying probate. What is that? It's the court supervising the administration of a decedent's probate assets. So the word probate pops up twice there. Probate is the verb of administering the estate, but probate assets is a noun, the things in probate. Double meaning, double complicated, sorry. Who supervises all this? Well, the administrative arm of the court is the Register of Wills. And so they basically oversee the process until or unless there's a fight. And when a conflict erupts, then the court gets involved. This should be called the probate court, but they call it the orphans court from old days past. What is bad about probate? Everybody wants to tell you, don't go through probate. Do everything you can to avoid probate. Well, as a probate lawyer, I can say, yeah, it can get mired sometimes, but by and large, it moves along fairly well. It just involves presenting forms to the Register of Wills on a timely manner and not ignoring when you're told you're late and you better get with it. If you ignore the court too many times, they will come and get you by the sheriff. So that's not good. An estate is supposed to stay open for this period, at least 6 months, but generally 7 to 10 months. That doesn't mean you can't do things like sell the house, but it does mean it's not officially done until the court says so. There will be some fees with probate, but they're not like taxes. They're not tremendous fees. And then the part some people find fascinating is that the probate process is public and the documents are public. So just to show you this quickly, if you were to Google Maryland estate search, this link would come up that you could click on, and it takes you to the Register of Wills website, and you get to the estate search page, and you put in as much information as you need to identify who you're looking for. A name can be enough if it's a unique name. So I put in a unique name, William Donald Schaefer. Yeah, the old governor of the state of Maryland. And if I put his name in and I click search, I get a quick summary of the governor's probate estate records. And this talks about when the estate was opened and closed and when he died, and some other dates. It also tells us who was in charge of his estate. We call that the personal representative. He had two personal representatives, and who the attorney was for the estate. But it gets better, because if I scroll down some more, I get a complete docket history, meaning every piece of paper that was filed in this estate is listed, starting with number 1, which is almost always the will, the governor's will. And you see that the will consisted of 11 pages. And look at this last column. Would you like to see a copy of the governor's will? Kindly check the box. Now, you do have to pay to play. They don't just send you his will. So it's 50 cents a page. I checked the box. It would cost me $5.50 to sort of snoop on the governor's will. But when I do that and I put in a credit card, typically that will is in my email inbox within about 10 to 15 minutes at the most. What else can I snoop on? Well, the inventory of what all his assets were, the final accounting of who got what, and then the estate is closed. So, yeah, and this is actually just a couple lines of his actual will that I was able to purchase for $5.50. So it's pretty public, but don't worry, your will is not public until you die. So you won't know who's looking at your will. Does probate have costs associated with it? Well, the biggest cost of probate can be the lawyer fee if it's a complicated, difficult estate. And most attorneys will charge by the hour, and that can be okay if they're using lower cost personnel like a paralegal to do some of that work. But the scary part is the law in Maryland says a percentage is also possible. And by possible, I mean a percentage of the probate estate if the judge agrees that the percentage is fair. And 3.6% is presumed to be fair as a fee for not only the attorney, but if a child is, or somebody's acting as personal representative, they may want a piece of the permissible fee. So they share it with the attorney. That's the real possible cost. Now, it's only fair if the attorney's doing 10, 20 hours worth of work that there be some fee. And you can certainly work with attorneys up front to say, how do you charge? And what do you think an estimate's going to be? And how do I cut down on your fees by doing things myself? But we like to think the attorneys do add value if they can move things along quickly, efficiently, keep things out of court, and maybe even address tax issues or disgruntled family members to sort of show them that their argument is not valid. But let the family handle other aspects of probate that can save money. Can we say probate is good for any reason? Well, it's good in the sense that probate follows the instructions and the terms you put in your will. So if you want to name a personal representative, executor, same thing, to do and make decisions about the real estate or other assets, and that way they make the decisions, not the children squabbling over those decisions, you can cut down on family discord. So the personal representative can say, children, here's mom's vacation home. How are you going to deal with it? And they're arguing and arguing and arguing. And the will says, if they argue, go ahead and sell it. So that's an extreme example, but one that is quite plausible. So now let's move to some estate planning for adult children. So you may have had wills when your kids were small because they were too young to control money. And now the children are grown, and the question becomes, are there any other reasons to address how your family inherits your money? And I bring out what can go wrong for the heirs after they get your money, after they inherit. So the 5 Ds of what can go wrong is how I refer to it. The first D is if a child gets divorced and has put this money in a general account, your in-law, your son-in-law, your daughter-in-law might be taking your inheritance from your child in a divorce, at least up to half of it. If you leave it to a child who gets sued or gets into a financial jackpot of some sort, the creditors can come after the inherited money. If your child dies after they inherit your money, where is that money going? Well, typically your children would leave, if they're married, they'd leave it to their spouse, your son-in-law or your daughter-in-law. But that may not suit well with you because don't you want your grandchildren to inherit as opposed to your son-in-law or your daughter-in-law? So these are just conjuring up possible things and how you could, we'll show you how you could address them. And then the last one would be disability, where you have a child who suffers from something already, like bipolar syndrome or a substance disease type of a thing, and you want to protect those assets from them. And we say death taxes because when family members inherit, it adds to their estate, and maybe they go over the limit for death taxes, at least for Maryland. So how do you protect against all these things? We go back to this schematic slide, but now we talk about it in terms of protecting. And where we focus is on the will down here. And we see that the will contains a provision to establish a type of trust that we give a nickname, a testamentary trust. And this trust catches all the assets that are going through probate and puts them into this trust. And it can also take care of beneficiary assets by naming the trust directly as the beneficiary of certain accounts that can name a beneficiary. The whole idea here is get everything dumped into a trust that then will split into equal shares for your children and let each child kind of run off with their own trust share, and they can be in charge of their trust. But the beauty of a child having their own trust share with your money in it is that none of those 5 Ds can occur as to that trust. So the spouse can't get it, the creditors can't get it, it can be said to go to your grandchildren and so forth. So that's something to bring up with your planning attorney if you kind of like the idea that, especially if you built up a nice nest egg, you don't want to see it potentially lost to your children. I mean, to your children's 5 Ds of what can go wrong. Now, I said I would circle back on beneficiary designations, that there are some unique ones that a lot of people are not aware of. If you have a bank, a credit union, you can actually use their form to designate a beneficiary of those bank accounts, savings account, money market, CD, and the POD stands for pay on death. And you can list children, and there's no cost to do that. So the bank has a POD form. The rest of your investments have something called TOD, transfer on death, and that works for mutual funds, something like accounts with Merrill Lynch, Morgan Stanley, RBC, those kinds of brokerage places. And then you can have a beneficiary on your real estate. And that's done usually through a lawyer to draft a new deed to be recorded, where you say to the attorney, look, I want to own my property the way I own it now for the rest of my life, but I'd like to name a beneficiary who will acquire the property automatically when I die without probate. And you can name 3 children, 5 children. So the attorney would draft a deed and it gets recorded in land records at the courthouse. If you're married, you both can stay life owners of the property, and the survivor of you can stay life owner. But at death, that's when the beneficiaries have ownership and take control. But before that, they have no stake in your property. So you can take them off, or they could get in trouble financially. They're not going to affect your ownership. A more elaborate way of having assets pass by beneficiary is establishing a trust now that you control and that you can revoke if you don't like it later. And I can only have time in this presentation to say, consult with an attorney as to why that trust may be worthwhile for you, because it may add a couple $1,000s to your estate planning to do this trust. But I do like it for people who are remarried with children on each side, and they want to make sure their assets do eventually benefit their own children, and a trust is a way to ensure that. And then you can actually designate a beneficiary of your vehicle, your motor vehicle. It's done right through MVA, the Motor Vehicle Administration. And I gave you some Google search terms here to sort of follow and get to the vehicle beneficiary page, where you enter this information, you pay your $20 fee, and you'll get a new title in the mail that designates a beneficiary on the vehicle. Should you die, they can instantly and easily take control of your vehicle. If you have a will, we remind you that that's great, but do you actually know where it is? And that seems kind of oversimple to say, well, of course I know where it is, but look at it. It may be a photocopy. It may not be the actual will that you signed. Photocopies are not a valid will. So where is your will? It might be at the Register of Wills. It might be with the lawyer. It might be lost, heaven forbid. So where do you put your will most commonly? Home is where people like to put it. That's fine. Make sure your family knows how to get in the safe, or wherever you put it, where they can get to it. The Register of Wills, even though they're called Register of Wills, they're not registering a will, but for $5, they will store it for you in the vault that they have. And that's an option. Safe deposit box, another option, but make sure someone else can get in it when you're deceased. Otherwise, you've just created a headache for them to get into your safe deposit box. Cost of estate planning certainly depends on how many services you're receiving. I would hope that most attorneys are charging you because you're getting some value added for your fee. You're getting an initial consultation to review all the issues, options, savings of ways to save tax and so forth. You're paying for them to then go and prepare those documents, and you're paying to meet with the attorney after they're executed to explain the implementation of your various documents. I would say in a basic situation, you're going to find attorneys somewhere between $1,000 and $2,000 for these, what I would say, comprehensive services. Yeah, can you get a shortcut for less than 1,000? Yeah. What's the shortcut? Maybe not spending all this time with you, because really the price of estate planning is a function of how much legal face time you're getting. Medical directive, that was our second important document, and you appoint a healthcare agent. Here's the dilemma with that document. What if you appoint an agent, but they don't know what your wishes are? Because the medical directives these days do not really spell out what your wishes are. And that's by design. That's designed because the state has developed a document to let you express your wishes. It's called a MOLST form, MOLST. I'll show you a slide on that in a minute. But how do you communicate with your family so they know what to do if they're in charge of your decision making? Well, you can first make sure the family member is given authority. And that's done by uploading a copy of the basic advance directive that names the family member. You can upload it to a site where all the hospitals and most of the doctors in the state of Maryland can see and download your directive. The state of Maryland chose this website, mydirectives.com, to store a copy of your advance directive and link it to the Maryland Health Care Network so that these facilities can access your directive. You don't have to carry it into the hospital. They can pull it down now by using mydirectives.com. And it can also say, hey, if I'm at shock trauma, here's who you need to call to get a hold of my family. So mydirectives.com has requires you to create an account on their site. And you can't really see any of this, but I'm showing you where on the website to click and then create an account. It's pretty basic as far as what they're asking you for: your name, your date of birth, email, phone number. So that's about as much private information they're asking for. And the good news, it's free. It's totally free to set up your advance directive to be available online to the medical people. Now, I jumped the gun. I started to talk about a MOLST form, and I should have waited for this slide. So MOLST is Medical Order for Life-Sustaining Treatment. This is a state of Maryland form, and most states have some version of it. It's supposed to be provided by your healthcare provider. And typically you're in the hospital, they come out with a MOLST form and say, hey, before your surgery, we just wanted to know what your orders are. What are you telling your providers that you want done or don't want done as far as treatment? You can opt out of life-sustaining treatment on this MOLST form. This has become the operative document for you to say what you want and you don't want. And once you're done your procedure, that MOLST form pretty much is stale, and then you can update it the next time you might need medical treatment. This is the worksheet that you would complete with your healthcare provider, and it turns into a medical order called a MOLST form. If you're incapacitated at the time, your healthcare agent who you designated can fill out your healthcare worksheet. What are the things on it? Well, the old law was that all you really had a chance to say is, do you want to be resuscitated or not? CPR. But that's only one question on this MOLST worksheet. It has about 9 parts to it. I've got most of them posted here, but you can talk about whether you want to have be on a ventilator, or do you want a blood transfusion, and so forth. And it even gives you some multiple choice options for some of these questions. So you fill this out, it gets signed, and then it goes in your chart as a MOLST form. If your child is filling it out for you, how does your healthcare agent, whether it's a child or a spouse, how do they know how to answer those 9 questions we were just looking at? Well, it'd be great if you could give written direction to your agent on what your wishes are, because they're not in the advance directive. The advance directive is just giving them the authority, but it's not telling them what you want, what your wishes are. So what do we have here? We have an ability to write anything you want, put it in any words you want. I wrote this one to help my clients give guidance to the family on how they would want their MOLST form carried out. So what does this say? This is not a MOLST form, but it should not be given to any medical providers. This is guidance to the family. Get a second opinion. Don't rush to judgment. And then I give you 4 horrible sounding possible scenarios you could be in. This is just one of them. Severe permanent cognitive disorder. Can't make decisions. Don't recognize your loved ones. And it's permanent. Well, a lot of people would look at that and say, I don't want any of these treatments on the MOLST form. So I check all of the above, like, let me go. Keep me comfortable. I'm not looking to be, suffering or anything like that, but I am requesting that you let me go. So that's a guidance form that you can make up, or your attorney may have some tool for you to use to do that. Our last subject, which is a quick 2 slides, and then we'll get to as many questions as we can, because I feel like a lot of questions are popping up. So long-term care, that's not really what you think of with estate planning, but it is important to think through, what if I need aides to come to my home? How does that get paid for? Well, Medicare doesn't pay for it. And you either pay out of your pocket or you bought insurance for it. If I can't stay home because it's too expensive, maybe I'll go to an assisted living facility. That's typically less expensive, but it's the same thing. You pay out of your money if you can afford what it costs, usually $10,000 a month for assisted living, or you bought insurance to take care of it. That's something you should look at if you've not looked at the insurance. One unique one is where you find yourself in a rehab environment, rehabilitation. That's often a nursing home, but it's temporary because you suffered some medical incident, you can't go home yet, and you need a lot of help. Medicare does pay some of the costs for rehabilitation, but not for long. 20 days in full, and never more than 100 days for a particular situation. And then the granddaddy of them all, as far as long-term care, is the nursing home. And this is the only environment where Medicaid might pay for the nursing home care. So notice Medicaid is not up here for the first 3, but it is there for the long haul in a nursing facility. How do you get Medicaid to pay? Well, unfortunately, you have to be out of money. Your assets have to be below $2,500. So that's where lawyers kind of stepped in and said, look, is that fair that you spend every cent of your life savings for a facility when there is a program that'll help pay for it with you? So elder law attorneys became sort of a new industry 30 years ago, and it's been thriving ever since. So for a single person, unmarried, they have to be below 2,500. They're told by everybody, like the nursing home, the state of Maryland, they're saying you have to spend the money at the nursing home until it's down to 2,500. But that's not what the elder law attorney says. The elder law attorney says, hey, you can give away some assets to your family and still get Medicaid to pay for it. If you think ahead enough to give it away 5 years before applying for Medicaid, you can protect everything you give away. Most people don't have 5 years warning that they're going to a nursing home, so they give it away at the last minute. But even then, some of that money will have to come back to pay for care, but not all of it. And so up to 50% of the money that you had when you went into a nursing home could be protected and get Medicaid to help pay the rest of the care. There's other techniques, but in the time allotted, we'll say consult your elder law attorney. For a married couple, the rules are different and more favorable because we have a healthy spouse that we don't want to take down to $2,500. That's crazy, but they still can only have 150,000. So the spouse at home can have 150, give or take, and the spouse in the nursing home can only have 2,500. At least the home is exempt from this calculation. So the spouse gets to keep the home and some calculation of money. Everything above 150,000, they're told to spend it down at the nursing home before Medicaid will pay. But again, that's not the real full answer. It's possible with the help of an elder law attorney that all the money above 150,000 can be protected within a couple months, and Medicaid can then kick in. So that's enough for me to cover for today. I'm going to leave you some takeaways from this presentation, and we have 5 or 6 minutes to address questions that I'll hear, I guess, from our moderator.
Thank you. That was